everyone. Thank you so much for joining our webinar today, Bootcamp for Healthcare Operating Companies. We hope that you are looking forward to it. My name is Kayla McCann-Marty. I'm a partner here in our healthcare group, and I will be presenting alongside my colleague, Tim Fry, who will introduce himself in a moment. We really enjoy having each of you. I know based on the list that I see a lot of familiar faces that have joined us for our webinars in the past. So you're probably pretty familiar with the platform, but I wanted to just do a little recap. Number one, about some technical things, and then number two, a little bit about McGuireWoods before we get started. So first, from a technical perspective, you should see a Q&A box on your slide deck. If you do have any questions during the presentation, please include the question in the Q&A box. Even if it's a fairly specific question, we'll try to answer it in connection with the presentation or at the end. If we're unable to answer it for whatever reason, due to time or specificity, we will reach out to you after the presentation to talk separately. Mine and Tim's contact information will be on the last slide, so do feel free to reach out to us anytime with any questions that may be helpful. So just before we get started, a little bit about McGuireWoods for people that may be a little less familiar with us. Tim and I sit in our healthcare department. We do a significant number of healthcare transactions as well as different work for healthcare regulatory companies. We are largely provider and facility-based representation, as well as their associated private equity funds and portfolio companies. So you'll hear us talking a lot about the different issues for operating companies from that perspective during our conversation today. McGuireWoods is a very large law firm, about 1,000+ attorneys across the country and now across the world. Most major cities in the U.S. have a presence, but our healthcare departments are also based all over the country with large concentrations in the Southeast and in Chicago. So if you are ever in our neck of the woods, please do feel free to reach out. We have two major conferences every year that may be of interest. The presentation we're doing today is a virtual version of the one we did at our Healthcare Finance and Growth Conference 2 weeks ago here in Charlotte that happens every year. And then we also have a similar offering, boot camp, that we do for healthcare companies at our healthcare private equity event in May in Chicago. If you're interested in any of those things, please feel free to reach out to us. We would love to have you or your affiliated companies at those organizations, and we would really welcome it. So with no further ado, we'll kind of get started here on the content of the presentation. The presentation really hit key topics that have been developing in the market over the last year. So they are very bite-sized, digestible pieces on different issues that are impacting operating companies that you can take action on to either make you more efficient, reduce your overall risk, or make you aware of some different issues that are happening in the regulatory landscape right now. So the first one is something probably a lot of you have heard about. These are state pre-close healthcare reviews. So many of us are very accustomed in connection with doing transactions, if a transaction of a certain size, having to file that transaction with the federal government under the Hart-Scott-Rodino Act, which we'll talk a little bit about here in a minute under one of our other sections. But many state laws across the country have been adopted, and you can see this map here that includes a lot of them that have either recently passed, have been considered, failed, and these are changing constantly. So this map is only accurate as of recently, but they are coming online each month effectively with different states. And so if you have operations in any of these states, or if you're looking to buy a company in any of these states, then you need to be aware of these healthcare transactional rules. Some people consider them antitrust rules because in some situations they're structured very similar to Hart-Scott-Rodino. In other scenarios, actually, though, they're impacting things like healthcare quality, access, and cost. And so they sit more within the vertical of healthcare departments within the state. For example, California is regulated by a department called OCA, and that is largely about healthcare access and cost. and a little bit less about traditional kind of antitrust market overlap type issues. So these are some things to be really focused on. We wanted to just point it out to you all so you're aware these exist, and you can be really mindful of whether they exist in your states that you're looking at or one that you may be looking to go into. They vary widely. They're based on a model rule in most instances that was originally developed in Massachusetts and has been tweaked significantly by state legislatures across the country before adopting these rules. They span anywhere from 30-day pre-closing notice requirements all the way to 90-day consent requirements. And so there's a couple of things you should be prepared for in connection with these rules. Number one, there's going to be a significant disclosure obligation in many cases. And so that means you need to start these early, be aware of them, be working through them to be able to get them completed on time. Number two, there's often a public element of your transaction. So many states, for example, like New York, if you make a filing, that filing is then posted on their website, and then people can comment on the impact of that transaction on healthcare in the state. So transactions that may be typically a little bit smaller, not having to be filed under Hart-Scott-Rodino, may now have a public element to them. And there are certain FOIA requests that can occur with respect to these applications that you file. So that's something to really be aware of when you're looking at these. And then the third is being very mindful of the type of documentation that's going to be requested in connection with these type of laws. In some instances, it's a very short filing where you complete the names of the parties, the size of the transaction, you submit it with no other supporting documentation. In connection with others, like California, it's a lot more onerous transaction to file on, and so you have to really pull together the data. It requires a significant amount of analysis. It sometimes requires production of documents that you have completed in connection with the transaction. So all of those things are something to be aware of. The next thing along the same antitrust vein is, I'm sure everyone has heard in the market that there has been a significant interest overall in antitrust issues across the country by the FTC. So one thing that's very helpful in connection with that renewed interest is being very mindful as an operating company of your antitrust policies and appropriate firewalling where necessary. So one thing that many companies can do to help increase their overall antitrust compliance and in connection with their compliance work plan is including implementation of an actual antitrust policy. Many organizations have this. I hope you all do, but if you don't, now would be a good time to look at implementing one to make sure it's very clear that people are being trained on antitrust issues. People know how to look out for them, especially outside of just payer rates themselves. That policy would include treating things like employee compensation, supplier relationships, things like that, and it can really help employees and it can really bolster your overall antitrust compliance. And in the event you were to ever have an investigation or if you were to ever have any kind of issue, this would be immediate indication that your organization is taking antitrust issues seriously, which I of course know you would be, but this can be very helpful in that way as well.
Kayla, if I could jump in with just one rip from the headlines here to kind of get people's attention, and this is Tim Fry. Some of my slides are coming up a little later. But one thing to just add to kind of shortcut this, the kind of really key case that focused operators' attention and private equity funds' attention was in Texas recently, where U.S. Anesthesia Partners and its PE sponsor were both challenged by the FTC under antitrust in terms of doing a roll-up strategy and then leveraging that, allegedly leveraging that kind of market concentration to increase payer rates. There was a lot of publicity when the PE fund was dropped from that lawsuit, but candidly, it was more of a technicality. The FTC was trying to stop both the PE fund and the platform from continuing what it considered illegal activity. and the PE fund had already sold the company. And so it's not as strong of a win as some people were maybe hoping. And so that U.S. anesthesia case in Texas and that kind of antitrust leverage, we're seeing more and more kind of government interest. And that's why things like what Kayla is sharing on adopting policy, putting firewalls in place is just so important.
Absolutely. And the other thing, Tim, I'm glad you mentioned firewalls, is looking at the way in which your organization can appropriately do things internally, so you're not always having to outsource services, but you're doing so by having appropriate firewalls by people who can see the information that may be competitively sensitive appropriately. So the best practice here is if you do have people within your organization that are screened off from each other in order to see competitively sensitive information that they're unable to use, is to have an actual firewall agreement. So now is as good a time as any to look at your all's policies, procedures, but also to actually look and see what firewalls do you all have in place practically, and which of those are documented in writing so it's extremely clear who is subject to which firewalls, and then having the appropriate security protocols in place to implement those firewalls. That's all very important in connection with an active antitrust policy. So I would just encourage all operating companies right now to take a look at that, particularly as they grow very quickly and could have competitive assets in similar markets. The next thing we're going to talk about is new HSR pre-merger agreement forms. So many of you all have probably heard about this issue because it has been percolating for quite some time, that there would be amendments and updates to HSR filings. There are many of you on the phone that probably do Hart-Scott-Rodino filings very rarely because your transactions fall under the size of person or under the monetary threshold for having to make a filing with the government. However, there's probably some of you on the phone who do these fairly frequently. So to the extent that you are doing HSR filings very frequently, you should be aware that there are updated requirements with respect to HSR that are going into place. And so this is going to make it much more onerous on companies to file HSR. It's estimated to take quite a significant amount of additional time and data to be able to make the filings, as you'll see here on the slide. And it's also likely to delve into information that companies have never had to file on in the past. And so we have entire webinars that are solely on this topic. So if you are interested in it, please let me know. I'm happy to get you the full piece of information about these new HSR filings or even connect you with our HSR expert on them. But the major things to understand are here on this slide, but also the action that operating companies should be taking right now is ensuring that all parties within your organization understand what these requirements are going to be for HSR and understand what documents are going to have to be provided in connection with an HSR filing, so everyone is putting their best foot forward possible in connection with any filing. So that's just to say that there's a significant amount of additional information that was never had to be provided before. Likely your all's organization is not closely policing or monitoring that information because it's not something that ever goes external or even maybe goes up the chain internally. And so that's something to really be looking at very closely, so you're not in a scenario where you're surprised if you do have a transaction that meets the HSR threshold, and then you do have to provide information you were not expecting or has not been vetted up the chain internally in the organization. So that's all I'm going to say about that. Just because we do have a significant amount of additional materials, we're happy to provide on it if anyone wants more information. The next thing are supplier relationships and conflict of interest actions. So many of you have probably either received or heard of a civil investigative demand, which is the government's ability to basically subpoena information about a company. What we are seeing across the country, across specialties, both provider, facilities, funds, there's a significantly higher number of CIDs being issued by the government in healthcare than we have seen in the past. That is largely emanating in our experience from different supplier relationships or other relationships that parties have that could be identified through conflict of interest forms. Many of your organizations may already do conflict of interest forms. So for anybody who doesn't, this would be a form that each of your employees, officers, and affiliated parties fill out that describe what financial relationships, what ownership relationships, and what other types of relationships those people have within the world of healthcare, so that you can understand, are there interconnectedness between those relationships that could have problematic elements from a kickback statute perspective, from a Stark Law perspective, or from any other government regulatory bodies. And so we're seeing this most commonly with different equipment and supply vendors, specifically around issues where we're seeing free items or services. We also have seen an increase in relationships that have contractual joint venture elements, if you all are familiar with that line of commentary by the OIG that is getting scrutiny by the government. Excuse me, guys. So to the extent that your employees, physicians, officers have those, you can identify them in connection with conflict of interest forms. When you do that, you can also, as an organization, determine how can we mitigate risk if those relationships exist, or do we need to terminate some of those relationships? My key takeaway today is really avoiding any unknown relationships so that those are not in place or keeping somebody up at night without them knowing it, right? If you have something going on you know about, you can mitigate for it. If you don't know about it, it's very hard to mitigate. The other thing that we often see in connection with these conflict of interest forms that you all may consider as organizations is updating them annually, so don't do them once and leave them on a shelf. And then number two, if the company is not receiving any benefit from the relationship, considering the party that receives the benefit from the relationship indemnifying the company for them. That's really all I'm planning to say on conflict of interest forms, but if you do have any questions about supplier relationships, again, this is low-hanging fruit that can be done immediately for operating companies to reduce overall risk. The last thing I'm going to talk about before I hand it over to Tim is compliance programming and ongoing compliance auditing. Every year, the OIG puts out their general compliance work plan or their program guidance, and it often says something brand new, something we've never heard of or we didn't understand they wanted. This year is a little bit different. This year, it was a lot of the same guidance itself about what has been required. However, the big focus area this year was the people who are expected to have a compliance program. So it's no longer the case that just because you're the operating company, you're the only person that needs to have a compliance program. If you, for example, own in a company that's doing this and you're actively directing that company, you're actively involved, the expectation would you would also need to have a compliance program. And you would need to make sure you're having auditing functions and monitoring that would allow you to have an appropriately functioning compliance program. This is something that probably all of us knew, but we may not be monitoring closely as our companies grow and making sure at all levels we are rolling out the compliance program in an appropriate way. So how do we do that? And this is something, again, is low-hanging fruit for operating companies to really reduce your overall risk. So first, make sure you have a dedicated compliance officer. So that's segregated from other functions. In an ideal world, that compliance officer would also report directly to the board rather than to any other executive. And so there should be a monitoring plan and an auditing plan in connection with that compliance officer that they're directing and have the appropriate level of compliance staff for your size of organization to be doing that. The other thing is not just for the operating company, but for example, private equity funds that invest in companies. An ideal world, they would also have a compliance plan and have staff training for individuals who are sitting on boards and doing other functions in connection with the operating company to receive appropriate training on compliance issues. Sometimes they will also have a code of conduct with respect to compliance that is best practice to incorporate that into your compliance program and policies, and we really do think that is very important. And the last one is a renewed interest, which I think all of us know to be true, but our organizations are doing at different levels, which is billing and coding. We see this as the #1 area that people have compliance issues. It is typically as a result of either inaccurate coding or over-coding, and it's typically not intentional. It's not a scenario where people are attempting to bill or code incorrectly. It's often due to a lack of training or a lack of information about the appropriate level of coding or billing that's required to happen. And so this is a place where really having outside reviewers, outside trainers with respect to billing and coding is hyper important, because you can identify those issues and correct them before they become a macro problem for the organization and you determine they've been going on 6 years and there's a significant liability to the company. So that's very low-hanging fruit to make sure that as billing and coding routines are happening very, very frequently. Tim, can I turn it over to you to comment on anything else you have on that and then get us kicked off with corporate practice?
No, well stated, Kayla. I definitely think, the kind of billing and coding is an important issue. I'm a history guy, so partner in the healthcare group, work with Kayla closely on regulatory matters. Thank you all for being here today. We're going to talk corporate practice. We're going to go way back 120 years ago when across the country, states made the decision that companies are not people, companies cannot have ethics, therefore companies cannot practice medicine. And let me be very, very clear, that's not my view. That's just the view of why a lot of these laws were passed. When we presented this in Charlotte, some people commented that I didn't like providers. I love providers. I spend all my time with providers and spend all my time with those that invest in this space, folks like you on the phone. But that's the history of it. The history of it is this belief that profit motive has to be divorced from medicine. Lo and behold, it can't really be done. Humans are humans, including doctors. And over time, obviously, there are investors in the physician space. So why am I bringing up 120 years of history and some ethical arguments? I'm going to go back to that slide in just a minute. But it's because we are actually seeing, I don't want to say a rebirth, because there used to be every 10 years a corporate practice case, but we're seeing quite a bit of action right now. So we are seeing in California a recent challenge to Envision Health, an emergency department staffing company that was brought by a trade association. In California, the case eventually ended and Envision kind of agreed to depart the state. They said it was unrelated, but certainly the trade society believed they won this case over corporate practice considerations. We're seeing where I am this week. I'm usually based in Chicago, but I'm in New York City today. In New York, and it's stepchild New Jersey across the river. We're seeing a whole set of cases where auto insurance companies are bringing corporate practice challenges so that they don't have to pay for care after auto accidents because the practice wasn't set up correctly. Maybe there were management agreements without fair market value fees. Maybe there were non-competes that made it improper, or violations of corporate practice doctrine for other reasons. We are seeing Texas put even more emphasis in the last couple of years than they have before. And things like what Kayla said at the jump around state filings before healthcare transactions that you want to be thinking about getting your house in order to participate in those transactions is also leading to considerations about corporate practice doctrines. So California didn't pass a bill on this, but it would have put in law, in statute, some of its Board of Medicine guidance and put it with even more teeth that made it more difficult to invest in healthcare provider companies in the state of California. Oregon's looked at something similar. Colorado, we've seen the Attorney General enforce some corporate practice related and antitrust related things against healthcare companies. So we're seeing this, maybe antiquated, some would say, historic, certainly something that has been very important in terms of structuring relationships between investors and physicians over the last 80 years, especially the last 25 years, kind of come back in the fore. And if you're not being thoughtful, there are states now looking to make actions here. So as a healthcare operations company, what can you do? Going back a step on action. First, obviously, before investing, make sure you know the then current applicable CPOM laws and requirements. Make sure you know what this acronym even stands for. How do you avoid layperson control in the given state? But then be thoughtful. Hey, if it's a new day, maybe more enforcement action. Is it time to look at our restriction documents, whether that's a share transfer restriction agreement, non-compete agreements with our physician owners? Are we ensuring that we are actually taking decisions when they need to be to physicians? When are we just supporting them? When does the state consider things clinical? All of these things are being looked at again, and so when you're an operator, especially in the physician space or the dental space, but also veterinary, physical therapy, kind of those healthcare providers, just need to be thinking and thoughtful around, are we doing things? Are we thinking about state law? Are we kind of updating to some of this recent enforcement action and therefore some of the guidance we're getting out of it? Kayla, did you want to add anything on corporate practice before you transition to physician office drugs?
Nope, I'll go ahead and transition now. So many of you may be aware that there has been quite a bit of action about mailing of drugs from physician offices. You all may be involved in trade organizations. You may be involved yourself in lobbying efforts around this, but since 2021, there's been quite a bit of activity. So all we're going to do today is just provide you an update on where the activity stands. So many of you and your organizations, if you're part of a physician practice or you support a physician practice, may be relying on the in-office ancillary services exception to the federal Stark law. Under that requirement, and this has always been the case, it requires drugs to be dispensed at certain locations. However, prior to 2021, there was a lot of questions about whether or not mailing a drug from a physician's office was considered meeting the in-office requirements under the in-office ancillary services exception to Stark. In 2021, September specifically, in came CMS with an FAQ that clarified their position at the time, and this was through a guidance document. This was not through formal rulemaking or through statute, that their position was that mailing drugs did not qualify for the in-office component of the in-office ancillary services exception. That FAQ came as a surprise to a significant number of providers and a significant number of trade organizations. And so the trade organizations largely disagreed with CMS's position in the FAQ, and specifically they disagreed with the fact that it was being done in an FAQ rather than in some kind of rulemaking, which they viewed would have been required, or in statutory authority. So you all may be aware, one of the trade organizations filed a suit against CMS and the U.S. District Court for D.C. About the FAQ and the appropriateness of the rulemaking around that particular issue. That had been adjudicated this year in August of 2024, and at least at the district court level, the district court affirmed CMS's position that they were permitted to issue the FAQ and basically said that they at least weren't going to stand in CMS's way of interpreting the in-office ancillary services exception in this way. So what that means for all of you is really just to be aware that this exists, be aware of the disagreement between the trade organizations and CMS about this particular issue, especially as you all look at it for your organization and whether or not you're going to mail drugs or not mail drugs. The other thing to be aware of is a renewed interest in state fraud and abuse laws, specifically around whether the state law itself would restrict dispensing. And this can be typically done in one of two ways. One is there could be an absolute restriction on physician dispensing in any connection that is not in person as a result of the physician's state dispensing license. The other ways that you can see this is sometimes there is a pharmacy license itself required for the entity if they do have any delivery by mail or if they do have anything like that. So just this is a renewed area, if you do have an in-office pharmacy, if you do have dispensing by physicians, it's really important that you, number one, familiarize yourself with this FAQ as well as the district court ruling because this is a new and updated area of interest for a lot of people. And number two, you be very familiar with the particular state dispensing laws and state requirements in order to dispense either in person or in any other fashion because that can be important right now. You may also be following that as a result of the district court ruling in D.C., there has been a new bill introduced at Congress that would affirmatively allow physicians to dispense to their patients by mail. And so this has not been enacted into law yet, but it is pending. There's a lot of trade organization support behind it, but that's something you may want to follow as well. The next issue that I'm going to speak about for a minute is just Medicare disclosures and enrollment. If you're like many people, you probably filled out your Medicare enrollment when you did your original setup. You probably add locations as you expand, but you may not consistently re-examine that every single year or every quarter to make sure it's accurate. There has been a real increase in, number one, required disclosures across the board, and number two, required updates to Medicare, where Medicare is taking affirmative action or, in some very extreme scenarios, terminating enrollment for not properly updating your PACOS enrollment. So there's a couple of scenarios where I would recommend every single person on this phone that's part of your organization ensure is being updated frequently and examined frequently. So number one, your representatives that receive contact from Medicare. That's something that you want to make sure is always updated. You never have someone that departs the organization and you don't transition that properly, because we have had multiple clients this year, and I know there's been so many organizations across the country that have actually been terminated from Medicare temporarily as a result of not doing proper revalidations, and then they have a gap in payment that's very significant. So make sure that those are updated. Make sure you're getting all the regular notices from Medicare. Nothing is being missed. It's being monitored and not by someone whose email has now been terminated because they left the organization. That's number one. Number two, pull your Medicare enrollment and take a very close look at all of your locations. Make sure all of your locations are fully up to date, the addresses are correct, they're being billed properly, because that is a place that we see a significant number of potential overpayments is when it is accidental that bills are going out of one location when they are really associated with another location. In many instances, that does not result in a payment differential because of the locations as being the same payment geographies, but sometimes it does. sometimes you're in a scenario that if you're in New York City versus in upstate New York, you see some payment differentials, and that could have a significant overpayment liability if it's not caught. So double check that in your PAYCOS enrollment. That's another way to really reduce risk. The other thing is something that people don't pay very much attention to typically, which are the ownership disclosures on your PAYCOS enrollment, as well as the management disclosures on your PAYCOS enrollment. Please take a look at this section of your PAYCOS. You should be reporting anybody who owns more than 5% of the company up the chain. So take a look at that, make sure that that reporting is right. That is a scenario where that can be a technical error with Medicare, but can result in liability for the company if that's not being done properly or updated properly. The same thing is true if you have changes in management companies or people who are managers or officers that control the company. Those all have to be listed as well, and we're seeing that commonly be an area that is inaccurate, not intentionally, but because it's not being reviewed properly or it's not being reviewed commonly. So that's very important that that requirement is not just sitting with kind of the lowest level person in your organization, that there really is a reporting structure to review that internally to make sure in many instances a significant payer of your organization is not going to have a liability against you as a result of any of that information being wrong. The next, we're going to talk about a little about billing as well, and Tim is going to take this one on Incident 2 billing. I assume many of you all have this in place and may be interested here.
Hey, thanks, Kayla. And just on that past slide really quick, it's so important to update the contact information. I know it sounds silly, but those of you on the phone are probably not the people in your organization that is listed with Medicare. But who's listed with Medicare is going to be who gets the outreach. And often it's our, I don't want to say our lowest rung employees in an organization, but it is certainly not your C-suite that is usually listed as the people getting contact information. And having worked for a number of clients that went through what Kayla described of losing billing privileges, the government has zero sympathy for the fact that your contact that you gave the government and were required to update has left the organization. Zero sympathy. They assume you are giving them the highest priority and most important person's attention in your organization. That's usually not the case with these types of signups, but just understand that's their vantage point in view. So it is important, it's critical, as Kayla said, to try to update that, look at PAYCOS this month before the end of the year and get it updated, because if they do outreach and you don't get it, you could be in a world of trouble. Incident 2 billing is often somewhat similar. So for those on the phone that don't know, under the Medicare physician fee schedule, if you have a nurse practitioner or a physician assistant do a service incident to the physician service, they can get paid 100% of the fee schedule instead of 85%. And that 15% differential can be the difference between a physician practice breaking even or making profit on the year. So it can be a very significant piece of people's business. The problem is often Incident 2 is misunderstood. It's very complex. You have to go to the Medicare manual, which we have a screenshot of, to kind of fully understand all of the elements and requirements. Sometimes the billing staff starts to figure out, well, if we put down the physician, not the MP, maybe we put this modifier on, it's going to get paid more, and they just start doing it out of habit. They don't necessarily check that everything's in place. And so what needs to be in place? It needs to be a follow-up visit on an established plan of care created by the physician with physician oversight in the office suite on the day of service. So the government can, if they look into this, can find out, well, you were doing Incident 2 billing for a brand new issue. Maybe you were seeing the patient for knee pain in an orthopedic practice. There was an established plan of care, But during the patient's visit, they started complaining about ankle pain, and the NP started working on the patient's ankle. Well, that's a new issue. You don't get to bill 100%. And so when it gets audited, often in a deal or in a government audit, RAC audit, that can be a problem. So NPs, PAs, they often can bill independently of physicians. You do not have to use Incident to, but the Medicare program will only pay 85% of what the physician bills at, unless it's done Incident to. So there's this big economic incentive to push you that direction, but you have to follow the guidelines. And then this can actually go worse for practices. It's one of those things, if a practice is being investigated for False Claims Act liability, civil fraud, etc., the government loves to put in front of a jury or in front of the trial court that the doctor was traveling, and they always love to find the example where the doctor is in the Caribbean or Europe, and then bills were submitted under his or her name on dates that he or she was out of the country, to say this was not just a 15% overpayment, the entire claim was fraudulent. And we see this a lot, comes up in so many of our deals. Yes, you can do Incident to, but if your organization doesn't have good policies around checking that it's an established patient for an established plan of care, and there was a physician in the office suite to supervise, then we would encourage you to do some internal auditing and make sure your Incident to billing is correct, because it's just low-hanging fruit that auditors, billing and coding audits during deals will look at and go after.
And Tim, can I add one more thing there? Because sometimes this is a common point of confusion, which is the difference between required supervision from a state law perspective and Incident to requirements under Medicare. So every state is going to have a different requirement with respect to what supervision is required for advanced providers under their state law, and that's as a result of the licensure regime. And then there's the Medicare requirements with respect to billing that are separate. And so in our experience, a lot of people get confused between those two differences. Like in many cases, they can be fully in compliance under the state law licensure requirements for that person to practice independently, but, they are not able to bill under the physician's number from an Incident to perspective. Then they have to be billing under the mid-level independent provider number and being reimbursed at that 85%. I just wanted to clarify that element.
Thank you, Kayla. Kayla,
okay,
did you want to talk corporate transparency?
Yes. The next item is the Corporate Transparency Act. I hope many of you have heard about this, but I do believe it's been a little under-publicized for a lot of organizations, so this may be the first time you're hearing about it. The Corporate Transparency Act here, you can see, was enacted in 2021, so quite a long time ago, and it was really aimed at ensuring that there wasn't money laundering, tax fraud, or other kind of activities happening by companies that the government didn't have any insight into knowing who the owners were, what their operations were they employing individuals, and was the money running through it legal. And so beginning in 2024, we started to see the first required reporting process under the Corporate Transparency Act. So the way that this works is certain entities, and you'll have to look at each of your entities. This is not on an entity-wide basis, but on like a legal entity by legal entity level, and whether or not they have to file who their ownership is with FinCEN. So this is the same organization who regulates certain other financial institutions, but this is now an expansion of their responsibility into all companies in the country who do not meet another exception. So there is a significant number of exceptions for reporting, but some of the entities within your organization may meet that, and some entities may not. And so it's critically important that you all take a look at each of your entities to determine whether or not filing is going to be required. So here's a quick little pictorial that shows you about what happens for existing companies and what happens for new companies, because the two required reporting periods are a little bit different. So you can see here in this pictorial, if you have an existing company, and how that's defined is any company that was either created or registered to do business before January 1st, you must either meet an exception for that entity or file a report for that entity by January 1 of 2025. So now would be the time to be pulling all of your entities to determine whether they meet an exception. There's two ways to do this. One is you may have a person within your organization or externally consulting for your organization that already is looking at this. And if you do, that's great. That's probably all you need to be doing right now. If you haven't thought about that, though, at this point, probably the best pathway is to reach out to your registered agent. Many of the registered agent entities, like CT Corporation, are providing this service to their clients for a pretty reasonable fee, and they can look at all of your entities, make a determination whether a reporting is required, and then actually submit the reporting for you. If you need contacts on that, please feel free to reach out to Tim or I. We can absolutely get you connected, or we can assist you in making a determination of whether or not reporting is required. Then we have a second bucket of companies, right? These are your new companies. So if you form something after January 1st, as you can see, from now until the 1st of January of 2025, you have 90 calendar days. So from the date of formation for 90 days, you have to file on those entities if they don't meet an exception. However, as of January 1, you'll only have 30 days. So that's very important to make sure you all are on top of that and you're aware of those timing requirements. The reporting process is pretty simple. So we just wanted to highlight this for your all's radar so you all can be checking on it. Tim?
And we are starting to round third base. So just a couple more topics to just hit on that you should be aware of and taking back to your organization, your healthcare organization, to kind of add to the work plan. But based on the first 50 minutes of this webinar, please feel free to use the Q&A box, and we'll either try to answer in the last 2 to 3 minutes, or we'll get back to you after the webinar today, and we'll look forward to continuing the discussions. So the first one here on your slide is new rulemaking that the Office for Civil Rights has put out with a number of requirements to avoid discrimination in healthcare services, including the Medicare and Medicaid programs. We've tried to put seasonal appropriate icons on the slide. So there are a couple things that you need to have already made sure of. You're supposed to make sure those that need help with effective communication because of disabilities, i.e., they're deaf, they're blind, they have some other disability that makes communication difficult. You need to be ensuring effective communication. And then you also need to already be ensuring meaningful access for those with limited English proficiency, whether that's because they grew up with a different language or whatnot. This fall, here in 2 weeks, you're supposed to have appointed a Section 1557 non-discrimination coordinator and also be providing patients a notice of non-discrimination. By the spring, after showers, your May flowers will come. My children will be very upset that I got that rhyme wrong. You'll need to be checking on patient care decision support tools. So at its most glossy, artificial intelligence, but it could even be as simple as spreadsheets helping with patient flow. You need to make sure that somehow in there you're not inherently biasing against racial, ethnic, gender discrimination, and then you can see by next summer there is more to come. And we're going to be having some upcoming webinars all on this in Section 1557. I will say there is a number of litigation efforts with respect to this law to throw it out, especially with respect to the definition of gender and sex. If you're in a swing state for political purposes, you'll know why gender and sex is highly politicized and charged, since I think it's the frequency of most of the politics of some of the candidates. But because of that, some courts have gotten involved and at least have paused certain things around gender and sex discrimination. The rest, however, is likely to stay in place pending the election this fall, because there has been kind of a yo-yo between the Democratic administrations recently and the Republican administrations in terms of how detailed these rules are going to be. And a second Trump administration would likely do what they did in the first Trump administration, which is dial back some of these rules. But if it stays in place through July of next year, here is some of what you're going to be expected to do in order to participate in the Medicare and Medicaid programs. Also, we are seeing so much with cybersecurity that while it's not necessarily a legal issue in terms of adopt this policy, put a certain contract in place, but we are seeing that because hospital systems are going offline, because hackers are putting people in a position where the care is being compromised, we're seeing malpractice lawsuits brought. We're seeing cybersecurity insurance policies being utilized to try to get people back online. In my town of Chicago, our major children's hospital went down and didn't have phone services. They had to literally go to Verizon and T-Mobile, is my understanding, and pick up new phones so that they could communicate internally. This is something that in all your organizations should be keeping everyone up at night. It keeps me up at night in the law firm. And so making sure your IT professionals have the support they need, but then also thinking about backups. And we put cybersecurity on here, but you could put hurricanes causing IV fluid needs in crisis mode. All of that, backup, something all healthcare organizations need to think about, even if it's not purely a legal issue. Had we done this presentation 2 months ago, this would have been our first slide, and we probably would have spent half of the presentation on it. 2 weeks before the rule was set to take effect, the FTC's rule that would have banned non-compete clauses was stayed or paused or thrown out, depending on which adjective you want to use, by a judge in the Northern District of Texas. So that's good news for those of you on the call that rely on non-compete clauses. For those of you that think that's vital to your business, you'll know, hey, the FTC rule, getting rid of them is not enforceable right now. It is not the law of the land. The rule was thrown out. That said, a couple notes of caution. First, the FTC has appealed the decision. They're taking it to what is typically seen as a pretty conservative Fifth Circuit. So it's likely, I think a lot of the prognosticators are of the reasonable belief that the district court judge's decision will be upheld by the Fifth Circuit, but it's on appeal. We'll see what the circuit court does. That's one. Two, the FTC can bring its own actions, and has signaled it probably will, pointing to the exact things that they didn't like in the non-compete clauses. They can say, no, we don't have a rule. No, the rule is not enforceable, but we still think your non-compete clause as an individual healthcare company is violative of competition laws, and we can go after you as an individual. Absolutely expect the FTC to do that in a few cases. They've already done it while the rule was pending. They're probably going to do more of that. So for any of you with broad non-competes, just think about that. And then 3, the National Labor Relations Board, usually seen as kind of where a lot of union disputes go, has also kind of announced that it's going to be acting against certain non-compete restrictions, that they view that as a restraint on the ability of labor and unions to organize, to kind of work between each other. And so there is going to be more pressure at the federal level. And then 4th, there's more pressure at the state level. Every couple months, we're seeing another state get rid of non-compete clauses or limit them or restrict them or pause them in some way. So now is a perfect time. Use the FTC rule being paused and thrown away to kind of pause. Call the company together, call your operations team together and say, okay, what do we have right now for our non-competes? Is our non-compete actually protecting the business? I.e., are we asking for a non-compete that's across all the Southeast United States, even though our patients only come from 5 miles away? If so, a judge is never going to, I shouldn't say that. A judge is unlikely to enforce a non-compete across the entire Southeast United States for an office located in Augusta, Georgia. So think about that restriction. How long does it last? If a doctor left our practice and, we had them sit on the sideline for 2 years, is that enough to protect ourselves? Do we really need 10? So those are things that, take a look at, talk to your legal counsel, you talk to our team, talk to our LME team, but there are some ways to kind of be targeted, reconsider non-competes during this time, and make sure they're still potentially enforceable. So we've given you a lot of different things today. We also recognize it's a bit of a mouthful hearing from 2 lawyers talk for an hour and only getting a chance to throw in some Q&A, which we've tried to address throughout, but for the handful of folks we didn't respond to, we'll send you a note after. If you have questions, please use the chat box. But 5 kind of key actions you can take right now. Like Kayla said, make sure you have a conflict of interest form. If it comes up, it's going to be something you look at. 2, think about your antitrust program. Can you get a policy in place? Get training in place. Low-hanging fruit in case you're doing transactions if you were ever challenged either by the federal government or state governments on competition. 3, make sure dispensing of drugs are concurrent with what Kayla said. We are now seeing more people interested in that mailing of pharmacies and potentially challenging that. 4, before year end, determine if you have to file under the Corporate Transparency Act at the federal level. Should be a pretty quick check, but do it so that you don't get fined after January 1st. And then 5th, cybersecurity, other backups. It's just going to be the thing that keeps us all up at night. Get ahead of it before it happens to you. And with that, on behalf of Kayla and myself and the entire firm, we're so glad you joined us. Hopefully, by hitting about 12 different topics, there's at least 1 or 2 and those 5 actions that you can take back. As Kayla said, we'd love for you to join us at our healthcare private equity event in May in Chicago, and of course, sign up for additional thought leadership through our website. With that, if we didn't answer your Q&A, we'll make sure we send you an email. And with that, we'll ask Shad at On24 to close this out. But thank you again for joining us, and you have a wonderful 4th quarter, please.